Oops. Okay,
Okay,
perfect.
Judge, we're ready now.
Okay. All righty. Good afternoon. This is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for wrong docket. October 5th, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Good afternoon, everyone. Mr. Pantoja, would you call our next case?
Yes, Judge. It's cause number 2021-020-0641, State of Texas versus Christopher Rick Martel. Cause number 2021-020-0640, State of Texas versus Randy Alexander Martel. Announcement of council, please.
Brian Herrera and Michelle Hill for the State of Texas.
Good afternoon, Your Honor. Joe Spencer on behalf of Christopher Martel and standing in for Felix Valenzuela on behalf of Randy Martel. As you probably know, Your Honor, Mr. Valenzuela is in a federal trial right now.
Yes, and thank you everyone for working with one another. I know with these quick resets, schedules can be hard to accommodate. So thank you all.
Judge,
I think we're
Judge,
missing one defendant.
Okay, that's what I was gonna let the annex know. Annex, if we could get both the Martel, Randy and Christopher, please.
Yes, Your Honor, can you give us about 5 minutes? Because we only had one Martel, but we'll get Christopher right away. They didn't give us his name, but we'll get him right away.
Okay, so Mr. Spencer, I guess the one we are missing is your client. Are you okay to proceed without him for now? And just as he gets here?
I am, Your Honor.
Okay, great. And so we do have Mr. Randy Martel again, Mr. Spencer standing in. This is an ongoing motion to review evidence. Ms. Hill, I don't know that you were here the last time, but I feel very comfortable that you're up to speed. Mr. Cox was here last time. And so we were awaiting, from my memory, Mr. Cox was going to arrange, it was represented by the state, Mr. Spencer, that a request to the law enforcement agency had not been made from the DA's office to actually start testing any of the evidence. And I guess therein lied some confusion. Ms. Hill, what is the update for today?
Yes, Your Honor, thank you. With regard to the evidence review, we did meet with the criminalistic unit on Friday. There were a total of 165 items reviewed. 22 of those were submitted for forensic testing. The anticipated date with regard to those being completed is between 120 to 180 days was the estimate. They couldn't get it any closer than that, but it should be within that time frame. But we did address that issue. With regard to the autopsy report that has been uploaded into portal for view.
May I ask, what is the date of the autopsy report?
I have to pull it up on our system. I apologize, I didn't have that with me. Let me log in. If you give me 1 second, Your Honor, let me see if I can pull an actual hard copy.
Sure.
Mr. Herrera, I didn't quite hear Ms. Hill. I heard there was 22 items submitted, a total of, was it 120, did she say, or
165, Mr. Spencer, and
165?
Then, yes, sir.
Okay, thank you, sir.
All right, Your Honor. It appears that the postmortem examination was completed on the 14th day of December 2020.
Okay, so this is significant for me because I think it had been requested. Mr. Spencer, can you give me an idea? I don't know if that was in the motion. It sounds to me then there was an ME report. It was just never produced by the DA. Is that right?
That's correct, Your Honor.
All right. So we've got 22 out of 165 items that may have a turnaround time of 6 months.
Yes, Your Honor.
So in my understanding from what I heard at the last hearing was that the testing does not get started, and I'm trying to understand the process until the DA's office requests that it get tested, correct?
That's correct, Your Honor.
So is it safe to say that Mr. Martel, the Martel clients, I think have been in custody since February, Mr. Spencer?
That's correct, Your Honor.
So as this case was pending, I have to ask Ms. Hill, what had the DA's office done to move the testing along to make the evidence available to defense counsel, since this case was indicted early 2021, clients have been in custody, and I know this trial setting has been, I guess, on file for a good 9 months. What was the DA's office doing with this case for 9 months?
Your Honor, with regard to the case, I'm sorry, I'm getting feedback. Hello? Can you all hear me?
Yes, ma'am.
Yes.
Okay, thank you. With regard to the previous prosecutors who were handling the case, I can't speak directly, as I think there was some miscommunication with regard to the process for submission of the evidence. I believe that prematurely they had a review. However, it was premature in the sense that items hadn't been sent off, and they were under the impression, I believe, that they may have been sent off. So they included counsel for the defense in the initial, I believe it was on August 24th, in which defense counsel did go to criminalistics. But at that point, it was discovered that the items had not been sent off. So in an effort for the items not to be contaminated and or compromised, that particular evidence review was stopped. And as soon as I became aware of the actual motion to review evidence, that's when we made contact with criminalistics as soon as possible. We set it for October 1st. We did the review and the items have been submitted.
Okay, but I guess my question is, for example, so Ms. Hill, have you been, is this a particular unit that is handling this case?
No, Your Honor, it's the actual court that's handling it. We did the initial screening. However, the actual case was set forth and placed in the line with the line attorneys for the 10th District Court. So we didn't have any other direct involvement. But once we realized that that was necessary, we did step in and made those meetings happen. We met with criminalistics and things have been submitted for testing.
Mr. Spencer, if memory serves, I believe you had, I don't know if it was you or Mr. Valenzuela, in terms of setting up that August review. I believe we're dealing with, was it Ashley Martinez and who else?
And Lindsay,
It was
Viraga?
Vergara.
Okay, so
Yes,
those,
as well as Stacy Schofield. They were the three that we had been dealing with, Your Honor.
okay, and those, I know Lindsay was a chief here. Ashley was our frontline prosecutor up until about May or so. So I guess this is where I'm having some trouble. And then Mr. Spencer, I guess I'll hear from you. It is your motion, but I'm having some trouble understanding how the process is, because now this is not the only case, I guess, this type of case in the past few weeks to come before this court, where it really seems like, so for example, unless Mr. Spencer and Mr. Valenzuela are making a specific request about reviewing evidence, there's really nothing being done. If there is an Emmy report, I think Mr. Cox represented last time that, we don't have anything to do with that. And I didn't quite understand that answer. Lo and behold, it's here, and it was apparently generated almost 2 months before the case was even indicted. And so, or something, I might have my timetable a little off there. So I'm having a real trouble, Ms. Hill, understanding, this case is set, let me go back because I'm going through Odyssey. My Odyssey is very slow. This case, set for trial December 3rd. How was defense to have an opportunity to review and possibly test evidence in time for trial when, you know, we have this setup for August 24th that really meant nothing because none of the pre-steps were done? And then, let me see. I mean, I just don't understand the process, Ms. Hill. I mean, when you talk about miscommunications, that's very difficult for the court to swallow, considering that we have two gentlemen, and Mr. Spencer, your client is now here. He's been here for a few minutes. I didn't want to interrupt Ms. Hill. You know, they're sitting in jail. And I don't recall if Mr. Spencer, if we've had a request for a bond before specifically. I know it's part of this motion, but basically we know nothing about any issues you might have with your case, Ms. Hill. We know nothing. And these people are sitting in jail. And so I need a little bit more from the state than to tell me there was a miscommunication and we just didn't make the request. Furthermore, we're sitting here and you're telling me that there are 165 pieces of evidence and 22 of them are on step 1. What's the reason for this, Ms. Hill?
Your Honor, all I can tell you is, you know, what I know with regard to the case. Once we have it, the 3 prosecutors that counsel for the defense were dealing with, 2 of those are no longer with the office. When our unit became aware of what we had, we went into action. We met the criminalistics, and we plan to do that going forth on any of the new cases. This case is not just strictly a forensic case. In this particular case, not arguing how counsel for the defense, of course, would argue his case. We know that it's of the utmost importance that these things be tested with regard to the state as the defense. So at my first opportune time, I did my best to contact that. I can't speak to the prior prosecutors. When I was aware of it as of Thursday, we made arrangements. We had everything tested. We uploaded what we have. And we will make available with regard to the remaining items. We will assist in any form or fashion with regard to counsel for the defense having the opportunity to review those and go see those items.
So what I can say before Mr. Spencer, we get to you, what I can say right now is 180 days is not going to cut it. And so we need to start looking at expedited options by court order. Mr. Spencer, can you chime in here, please?
Yes, Your Honor. Thank you. Your Honor, I will tell you, and I don't have, because it was Mr. Valenzuela that had the direct contacts with the DA's office requesting an update on the evidence to be reviewed. But we probably made 4 or 5 requests starting sometime in maybe March, April, around that line, when we started asking for the evidence at that point. At that time, it was a matter of getting collected, going to get processed. We'll get back with you. But it was Mr. Valenzuela who did that. So I can't give you the specific dates or the times on that, Your Honor, but I know that there were several requests made. The other thing that concerns me, Your Honor, is that the state picked 22 items to be submitted. I know that when I was there, I offered the crime scene technicians that were there that they could handle it, that I just wanted to, because they made a comment to me, none of it's been tested. We have to tell us what they want to be tested. I said, but I want to tell you what I want tested. He goes, no, you come in afterwards. Once the state does their testing, then you come and you tell us what you want tested and we're going to get done. That's just going to delay the process even more, Your Honor, which is real concerning to me. What is also concerning to me is I'm just now hearing, because I know we specifically asked for the autopsy numerous times, the autopsy report numerous times. Now I'm finding out it's been almost a year that it was complete. So I'm glad it's uploaded now, and we'll be able to have access to that. That really handcuffs us. And interestingly enough, I have seen Ms. Hill's response to our request for PR bond that was just emailed to me, and on the response to Randy Martel, she says that Randy was the shooter in the case, and therefore he's too much of a danger to the community. And on the response for Christopher Martel, she says Christopher Martel was the shooter in the case, and therefore he's too much a danger to the community. So I don't believe the state can represent in two separate motions, depending on when it's convenient for that specific defendant, and say they were the shooters. I don't think that's.
You're on. Oh,
Yeah,
I
I don't.
Mr. Spencer.
So
I'm
hold
sorry.
on, wait, let me stop you right there because I don't have that document. I don't know if it was filed. Marissa, if you can check if it was filed in this case. I'm just going kind of in general off of Christopher Martel's case, and I don't see that in Odyssey. Marissa, do you see it there, or who's here? Trisha? Sorry, I forget which clerk is here.
Your Honor, it should have been e-filed. If not, I can send a copy to you. But Mr. Spencer, with regard to the motion, Randy Martel, he shot the victim in the hand. That wasn't the actual bullet that killed him. Christopher Martel was responsible for the life-ending injuries. So there were two separate shootings. Mr. Martel did shoot the victim in the hand, that's a separate bullet casing, a separate gun. Actually, Christopher Martel is alleged to have shot the victim in the head. So it is, each motion is correct because there was a firearm used by both defendants. One a non-fatal injury, the other a fatal.
Is that represented in any documents that have been produced thus far?
Yes, Your Honor, and all the uploaded law enforcement reports, as well as the actual incident being recorded on video that was at the scene, as well as the entire killing being done in front of the 9-year-old son of the victim, as well as other witnesses.
Is the video available to you, Mr. Spencer?
Yeah, we have, Your Honor, and unless there's another video, what the video shows is we have the complaining witness whose moniker is Diablo, shows up with a gun and with a machete and two other individuals. And so they break into the house that the Martels are actually in. It is the ex-wife of the complaining witness with the son there. I mean, so we have a very strong self-defense case. Furthermore, as soon as this happened, there was indication to the Martels that they belonged to the Barrio Aztecas, and they immediately said they were out to kill him, and they started driving by the Martels' home. That's why the Martels fled the El Paso area, because they were in fear for their life. But the Martels family knew where Christopher and Randy always were, Judge. Nobody ever came knocking on the door to say, where are your sons? Because they were in the Dallas area, away from the unknown threat here in the El Paso area. But those are evidentiary issues that we're going to argue in the court or to a jury to make a determination whether we have a valid self-defense issue. But the video isn't quite as clear as what's being represented to the court, unless there's other videos that I haven't seen.
Okay. All right, and that to me is, just with every piece of evidence that is being discussed, I just want to see where we are status-wise on that. Some of this goes more to the consideration of a bond. I do not have the response, so if, let's see, if someone could email it to me, I don't know if it's in the court file, I'll look at that. But I know that's important, Mr. Spencer, the bond is important. We can address that in a minute. I am still
Yes, ma'am.
very concerned about what to me is minimal effort to do anything with respect to this case. 22 items out of 165 for testing and 180 days is not going to cut it. So
The other thing, Your Honor,
And Your Honor, if I may,
sorry.
Let me hear from
I'm
Mr. Spencer, please. Sure.
Yeah, I'm sorry, Your Honor. And I don't know what 22 items are being tested. That's the other thing that I'm a little handcuffed about. There are specific items that I know we want tested, but we were not able to actually physically look at the evidence and tell them we also want this tested. They shut us down and said, you don't get to look at it until after the state does. And after the testing comes back, then you tell us what we want. That was specifically what the lieutenant told us there at the evidence review.
Mm-hmm. Well, sure. I mean, if there's no direction, if basically the agency is being put out there without any direction from the DA's office. You know, all they know is that, you know, they have this evidence that hasn't been tested and nobody's told them what to do with it. You know, so there's a clear breakdown here, and it seems to be with your office, Ms. Hill. And so this is what we're going to do. Ms. Hill, before I keep going, go ahead. You were going to say something.
No, Your Honor, I was going to say with regard to protocols, with regard to testing, with regard to DPS, we're only allowed, we have to select 10 items that are the most pertinent for them to be tested. So when we go in and do an evidence review, that's why we don't just submit everything on the front end. With regard to the listing, Mr. Spencer, with everything that we did submit, those 22 items that we've asked to be tested, I will provide that to you, as well as any documentation that the criminalistics unit may have with regard to what they have. And as stated, I will do everything I can to assist you with regard to scheduling a meeting with criminalistics, so you can look at those items that were seized and that need to be tested or have been submitted, what have you. We'll
Ms. Hill,
make everything available to you.
Do you have a list of the 165 items?
I can get a full list, Your Honor, from criminalistics.
And Your Honor, those, I mean, those are up on portal. So that list is up and available for the defense to see.
Have you seen that list, Mr. Spencer?
Are you talking of, Mr. Herrera, the 22 items that were sent to be tested is on the list?
No. The 165 items are on portal.
Okay.
Right.
And we-
And they're the 22 items are inclusive in that 165. So I will pinpoint those that have been submitted.
Okay, Mr. Spencer, before we get to any bond, I need to know what suggestion or request you have of the court, how to proceed.
Well, obviously, Your Honor, the December trial date is just not a realistic date because the state is not ready and the defense is nowhere near ready, given the lack of the testing. The other thing is, I will tell you, is that we got a call, I believe, from somebody in the DA's office that there was some tapes dealing with this case that I had to come down to listen to it and make an appointment in the DA's office to listen to the audio tapes. I'm not understanding why I can't get a copy of those audio tapes. Ms. Hill, do you know what that is all about?
No, when were you contacted?
Your Honor, last week I was out of town in Dallas trying a case. My office told me that I got in. Today's my first day back in the office. I'm not sure, Ms. Hill, if it was yesterday or last week sometime.
Mr. Ardetta, do you know anything about that?
I don't. And
Was that based on a request? Mr. Spencer, did you request any audios specifically through Lenzui or any of the prior prosecutors?
Well, obviously we requested all of the evidence, and then as
Sure.
I understand, and what I was under the impression, what it might have been was a forensic interview of the child. But I have seen that, so I don't know if there's another audio tape or something. In all fairness to the district attorney's office, Judge, let me follow up with my office to find out exactly who made the call and when it was done and who I have to contact for this audio. And then I'll reach out to Ms. Hill and see if they can't just make me a copy like they do of the entire file.
Sure, we'll just make whatever available. Just let me know what you need.
And Your Honor, I mean, I know that there were forensic interviews that it looks like Mr. Valenzuela came in and watched in May at our office. So it could be something similar. I mean, I don't want to speak out of turn, but I mean that would make sense if it were those forensic interviews.
Yeah.
So
And
it
Mr.
sounds to
Valenzuela and
me-
I both saw that.
Yeah.
It sounds to me we need to get confirmation, a couple of things, Mr. Spencer, if you can check back with your office if you have some more details to shed light on this. But if not, the DA's office needs to go back and review to make sure there isn't any, I guess, audio tapes that have not been disclosed if they are not the ones that were reviewed by defense counsel, to provide them to Mr. Spencer and Mr. Valenzuela. So knowing now a little more detail from the DA's office, I want to see if we can accomplish something this way. There is a list available of those 165 items. The DA's office is to provide Mr. Spencer and Mr. Valenzuela the list of items that have been sent for testing. And I'm understanding that you have a turnaround time of up to 180 days. With that said, Mr. Spencer, for you and Mr. Valenzuela, I'm asking if you will please go through that list and to the best that you can, identify every other piece of evidence that you feel needs testing. If that means the remainder of the 165 all need to be tested, so be it. But I need some guidance from you and Mr. Valenzuela to see if we can't kind of put this together a little bit more cleanly.
Your Honor, I'm sorry to interrupt. Absolutely, I can do that. I know Mr. Valenzuela is going to be in trial for the next 8 or 9 weeks, but I don't have to wait that long. I can do that, and I'm sure Mr. Valenzuela will have the confidence in me doing that. But Your Honor, one of the things that would make it easier for me is that if I'm able to at least physically view the items so that I can identify them, it's very difficult sometimes to capture what is on the portal versus what is the actual item I'm looking at. So if I could do that, then that would avoid a further delay.
How can we set that up, Ms. Hill? How quickly can we set that up?
I will contact the criminalistics office today. Mr. Spencer, if you can let me know your availability, and we can set that up as soon as possible.
Yes, ma'am.
If you all are going to do that, initially what I was going to do was to just have you all come back on Thursday if you can ID them. If it's possible, if you all are going to work on that, I'm going to ask for an update on Thursday. You can do that via a jail slot on Thursday. It'll be at 10 a.m. on Thursday. At the very
She
least,
froze
I'll
to
know
me. I don't know if
when
anybody
you're
else has
going
her
to
frozen.
Sorry,
be.
Judge, I can't hear you.
Going to ask for, I don't know.
Yeah, everybody is slowing up for me. Can you
Okay.
hear me?
Yeah, you're freezing a little bit. Could you continue on, come back on Thursday if you can ID them, if it's possible, please?
So I'm setting a status at 10 a.m. If you
Okay.
all have an agreed to time and date to inspect so that you can make that identification, Mr. Spencer, please email Ms. Aguirre and me with copy, of course, to counsel, and just tell me, you know what, Judge, we're doing it on Friday, so the status it will be unnecessary. I just want it set up by that time so I know we're not leaving that behind. Anticipate, based on what you tell me about your review, I'm going to set a hearing immediately thereafter. If it can be Tuesday, great, because I prefer to do it at a time when your clients can be present. If not, we will just figure out a time after that. Okay?
Yes, ma'am.
I am not yet at a finality point, Mr. Spencer, in terms of the relief you've requested in the motion, so that your clients understand I am not at a bond yet through the motion to review evidence, but it looks like we are moving somewhat. So the status will be set for Thursday at 10, may be unnecessary, and we'll schedule a hearing right after that. What else do we need to address at this time, Mr. Spencer?
Your Honor, I would just ask Ms. Hill. Yeah, Ms. Hill, I'm sorry. When we get off this call, this hearing, would you call me, please, on my cell so we
Yes.
could visit?
I
Okay.
will do that.
Your Honor, that certainly seems very fair and logical. That looks like a good time frame, Judge. We should have some update for you on Thursday for sure.
Sounds great. And if you all need to come in for the hearing, no worries. We can take care of whatever we need to. We'll see you
Yes,
then.
ma'am.
Thank you very much. Thank you.
Thank you,
Thank
Judge.
you.
Have a good
Thank
afternoon.
you.
You too.
Bye-bye.
Bye-bye.
Who's next, Chewy?
I'm sorry. Annex, if we can take care of Armando Alonso, please.
Yes, sir.
Thank you, partner.
Is this a plea, Chewy? Yeah.
Yes, Judge, it is.
Okay, let me go back. right, regular stuff. Mr. Alonso, is that you?
Yes, ma'am.
Okay, great. Let's go again. You know, I just letting you know on the front end, I don't know if you could hear us, but I don't know if I'm getting some issues with my internet here in the courthouse. So if at some point I try and keep track of everybody's faces, if they freeze or slow up, sometimes it's my feed. But irrespective of that, if at any point you don't hear what I'm saying or you miss something, just wave and let me know. We'll go back and repeat anything you missed, okay?
Okay, ma'am.
All righty. I also need you to speak a little bit louder than you just did so I can hear you and the court reporter can hear you.
Okay.
Okay, thank you. Go ahead, Chewy.
Okay, Judge, cause number 2020-0D0-4990. Cause number 2021-0D0-1134. State of Texas versus Armando Alonso. Announcement of council, please.
Brian Herrera for the state of Texas. Ready, Your Honor.
William Martin on behalf of Mr. Alonso, ready to proceed, Your Honor.
And Ms. Martin, you see your client appearing from the jail annex?
Yes, Your Honor, he is.
Thank you very much, sir. I'm going to be asking you some questions, so I need to swear you in. Would you please raise your right hand? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Mr. Alonso, would you state your name for the record?
Armando Alonso.
Mr. Alonso, we are here for pleas on two cases. One has 2 counts. I'm going to be asking you about documents. You probably saw similar documents for each case. The first of which is marked as State's Exhibit number 1. Those are the plea papers for each of these cases. Within those documents, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Alonso, do you recall reviewing State's Exhibit number 1 for both cases with your attorney?
Yes, ma'am.
And did you sign those documents?
Yes, ma'am.
Did you understand everything contained within those documents?
Yes, ma'am.
Ms. Martin, did you explain the plea papers to your client?
Yes, Your Honor, I did.
And have you had more than 10 days to prepare defenses in these cases?
Yes, Your Honor, I have.
You believe Mr. Alonso has understood the admonishments, rights, and consequences of giving up these rights by entering pleas today?
Yes, Your Honor, he does.
And Mr. Alonso, are you satisfied with your attorney's representation of you?
Oh, yes, ma'am.
Ms. Martin, do you have any reason to believe your client is not presently competent to enter pleas?
Absolutely not, Your Honor. He's competent.
Mr. Alonso, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representation, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Chihuahua, but my mom was born in here. So,
So you're a U.S. citizen?
yes, ma'am.
Okay, so in each of these cases let's see, cause number ending 4990, there are 2 counts there of possession of a controlled substance in penalty group 1. As to count in an amount less than 1 gram. As to count 1, what is your plea, guilty or not guilty?
Guilty, ma'am.
And as to count 2, what is your plea, guilty or not guilty?
Guilty, ma'am.
And in cause number ending 1134, it's the same charge, possession of a controlled substance, penalty group 1 in an amount less than 1 gram. Guilty or not guilty?
Guilty, ma'am.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am. Friend.
I will find that you are making your pleas freely and voluntarily. Mr. Herrera, would you summarize the evidence, please?
Yes, Your Honor. Thank you. Had the state gone to trial in cause number 2020-0D0-4990, the state would have proven beyond a reasonable doubt that the defendant, Armando Alonso, on or about the 20th day of May, 2020 in the county of El Paso and state of Texas, did then and there intentionally or knowingly possess a controlled substance, namely heroin, having an aggregate weight, including adulterants or dilutants in an amount of less than 1 gram. As to count 2, the state would have proven beyond a reasonable doubt that the defendant, Armando Alonso, on or about the 20th of May, 2020 in the county of El Paso and state of Texas, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants in an amount of less than 1 gram. And furthermore, Your Honor, had the state gone to trial in cause number 2021-0D0-1134, the state would have proven beyond a reasonable doubt that the defendant, Armando Alonso, on or about the 5th day of March, 2021, in the county of El Paso and state of Texas, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in an amount of less than 1 gram. At this time, Your Honor, the state would enter State's Exhibits 1, 2, and 3 as to both cases. State's Exhibit 1 being the plea papers, State's Exhibit 2 being the Article 3914 disclosure form, and State's Exhibit 3 being the case summary and indictment.
Any objections?
Objection, Your Honor.
Without objection, State's Exhibits 1, 2, and 3 are admitted into each case. So what is the plea agreement?
Your Honor, 180 days via 1244A with credit for time served.
Okay, Ms. Martin, is that your understanding of the plea agreement?
Yes, Your Honor, it is.
And Mr. Alonso, is that your understanding as well?
Yes, ma'am.
Okay, I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Alonso, do you recall reviewing a trial court certification for each of these cases after you reviewed it with your attorney? Mr. Alonso? Mr. Alonso, can you hear me?
Can you repeat that, please?
Sure. The trial court certification, did you hear that part?
Yes.
Okay, so it's a one-page document that talks about your appeal rights. Because it is a plea bargained or negotiated case or cases, you do not have an automatic right of appeal. Did you hear that part?
Yes.
Okay, do you recall reviewing that document with your attorney and signing it?
Yes, ma'am.
Okay, it was signed by your attorney and signed by me as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2020-0D04990, I will find you guilty of 2 counts of the offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. And in cause number 2021-0D01134, I will find you guilty of the same offense, possession of a controlled substance, penalty group 1 in an amount less than 1 gram. As to all of these cases, your sentence will be 180 days confinement in the El Paso County Detention Facility. Pursuant to 1244A of the Texas Penal Code. These cases will run concurrent with one another and you will receive credit for any and all time that you have served. Is there anything further, Ms. Martin or Mr. Herrera?
Nothing further for the
Nothing further, Your Honor.
All right, thank you very much. Good luck to you, Mr. Alonso.
Thank you, ma'am.
All righty, who's next, Chuy?
Hey, Judge, Roy Mijares, Annex, if we could get Roy Mijares, please.
Mr. Mijares, this is Judge Perez. Can you hear me okay?
No.
Okay, if at any point you can't hear me, sometimes the internet gets a little choppy. Just let me know and we'll go back, repeat anything you don't hear. I also need you to speak loudly enough so we can hear you over here, okay?
Yes, ma'am.
Perfect. Let's get started. Go ahead, Chuy.
Yes, Judge. Cause number 2020-0D05881. Cause number 2021-0D00378. Cause number 2021-0D01901. State of Texas versus Roy Arthur Mijares. Announcement of counsel.
Brian Herrera for the state of Texas, ready, Your Honor.
Julia Martin, on behalf of Mr. Mijares, ready to proceed, Your Honor.
And Ms. Martin, you see your client appearing from the jail annex?
Yes, Your Honor, I do.
Thank you very much. Mr. Mijares, this is Judge Perez. I'm going to be asking you questions about documents you may have reviewed with your attorney, so I need to swear you in. Would you please raise your right hand as best as you can? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Sir, would you state your name for the record? I can't hear you, Mr. Mijares.
Roy Arthur Mijares, Jr.
Okay. I wonder if, okay, well, we'll try keep going. I feel like maybe the camera, the way it's angled, you might be too tall. Like, I don't know if it's picking up no, you don't have to. We'll fix it. We'll just keep going and see how it goes, Mr. Mijares. So Roy Mijares Jr., correct?
Yes, ma'am.
Okay, we are here for 3 cases set for a plea. As I mentioned, I'm going to be asking you about documents, the first of which is marked as State's Exhibit number 1. Those are the plea papers in each of these cases. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Mijares, do you recall reviewing the plea papers, State's Exhibit 1, with your attorney and signing each of those documents?
Yes, ma'am, I do.
Thank you very much. And did you understand everything contained within those documents?
Yes, ma'am.
Ms. Martin, have you had more than 10 days to prepare a defense in these cases?
Yes, Your Honor.
And did you explain the plea papers to your client?
Your Honor, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering pleas today?
Yes, Your Honor, he does.
Mr. Mijares, are you satisfied with your attorney's representation of you?
Yes, ma'am, I am.
Thank you very much. Ms. Martin, do you have any reason to believe your client is not presently competent to enter a plea?
Absolutely none, Your Honor.
Okay, Mr. Mijares, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor, psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Mr. Mijares, are you a U.S. citizen?
Yes, ma'am.
Okay, where were you born?
El Paso, Texas.
Okay. So in cause numbers 58, ending 5881 and 1901, you are charged in each of those with the offense of theft of property in an amount less than $2,500 with 2 or more previous convictions. As to the first case, what is your plea, guilty or not guilty?
Guilty, ma'am.
And as to cause number 1901, ending 1901, guilty or not guilty?
Guilty, ma'am.
Okay. Now in cause number 2021 0D00378, the charge is unauthorized use of a vehicle. What is your plea, guilty or not guilty?
Guilty, ma'am.
Okay. Are you making each of your pleas freely and voluntarily, Mr. Mijares?
Of course I am.
Okay. I will find you are making your pleas freely and voluntarily. Mr. Herrera, would you summarize the evidence, please?
Yes, thank you, Your Honor. Had the state gone to trial in cause number 2021 0D00378, the state would have proven beyond a reasonable doubt that the defendant, Roy Arthur Mijares, on or about the first day of October 2020 in the county of El Paso and state of Texas, did then and there intentionally or knowingly operate a motor-propelled vehicle, to wit, a Chevrolet automobile, without the effective consent of Lorena Galvan, the owner thereof. And furthermore, Your Honor, have the state gone to trial in cause number 2021 0D01901, the state would have proven beyond a reasonable doubt that the defendant, Roy Arthur Mijares, on or about the 11th day of February 2021 in the county of El Paso and state of Texas, did then and there unlawfully appropriate by acquiring and otherwise exercising control over property other than real property, to wit, a dog or a puppy of the value of less than $2,500 without the effective consent of the owner, namely Martin Carbajal, with intent to deprive said owner of said property, and is further presented that before the commission of the charged offense, the defendant had theretofore been twice convicted of a theft, in that on the 28th day of July 2011 in the County Court 2 of Potter County, Texas, in cause number 131251, the defendant was convicted of the offense of theft of property greater than $50 but less than $500 on the 28th day of March 2013 in the County Court 7 of El Paso County, Texas, in cause number 2013 0C03644. The defendant was convicted of the offense of theft of property over greater than $500 but less than $1,500, and it's further presented that prior to the commission of the charged offense on the 26th day of September 2013 in cause number 1675 in the 109 District Court of Winkler County, Texas, the defendant was finally convicted of the felony offense of forgery financial instrument. And is further presented that prior to the commission of the charged offense on the 18th day of December 2014 in cause number 2014 0D0 4738 in the 171st District Court of El Paso County, Texas, the defendant was finally convicted of the felony offense of robbery. And lastly, Your Honor, had the state gone to trial in cause number 2020-0D0 5881, the state would have proven beyond a reasonable doubt that the defendant, Roy Arthur Minjares, on or about the 23rd day of August 2020 in the county of El Paso and state of Texas, did then and there unlawfully appropriate by acquiring and otherwise exercising control over property other than real property, to wit, an inflatable air dancer with air blower of the value of less than $2,500 without the effective consent of the owner, namely Mattress Firm or Stephen Hernandez, with intent to deprive said owner of said property. And it's further presented that before the commission of the charged offense, the defendant had theretofore been twice convicted of theft, and that on the 20th day of July 2011 in the County Court 2 of Potter County, Texas, in cause number 131251, the defendant was convicted of the offense of theft of property greater than $50 but less than $500. And on the 20th day of March 2013 in the County Court 7 of El Paso County, Texas, in cause number 2013-0C03644, the defendant was convicted of the offense of theft of property greater than $500 but less than $1,500. And it's further presented that prior to the commission of the charged offense on the 26th day of September 2013 in cause number 1675 in the 109th District Court of Winkler County, Texas, the defendant was finally convicted of the felony offense of forgery of financial instrument. And it's further presented that prior to the commission of the charged offense on the 18th day of December 2014 in cause number 2014-0D04738 in the 171st District Court of El Paso County, Texas, the defendant was finally convicted of the felony offense of robbery. At this time, Your Honor, the state would enter State's Exhibits 1, 2, and 3 as to all three causes. State's Exhibit 1 being the plea papers, State's Exhibit 2 being the Article 39-14 disclosure form, and State's Exhibit 3 being the indictment and case summaries.
Any objection, Ms. Martin?
No, Your Honor, no objection.
Without objection, State's Exhibits 1, 2, and 3 are admitted as to each case. What is the plea agreement?
Your Honor, 15 months confinement in the Texas Department of Criminal Justice State Jail Facility, and the sentences are to run concurrently.
Ms. Martin, is that your understanding of the plea agreement?
Yes, Your Honor, it is.
Mr. Minjares, is that your understanding as well?
Yes, ma'am.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page trial court certification of your right to appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Minjares, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
They were signed by your attorney and signed by me as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2020-0D05881, I will find you guilty of the offense of theft of property in amount less than $2,500 with 2 or more previous convictions. I will also find you guilty of that same offense in cause number 2021-0D01901. In cause number 2021-0D00378, I will find you guilty of the offense of unauthorized use of a vehicle. Your sentences will each be 15 months confinement in the Texas Department of Criminal Justice State Jail Facility pursuant to the plea agreement. Those sentences will all run concurrent with one another and you will receive credit for any and all time that you have served. Is there anything further, Ms. Martin or Mr. Herrera?
Nothing for the state, Your Honor.
Nothing further, Your Honor.
Good luck to you, Mr. Minjares. Yes, sir.
One question, Miss. How is the time running for now in state jail? Is it still 80% or how is it going on?
I'm not sure exactly what you're asking. Ms. Martin, happy to put you in a breakout room if you have questions or you want to answer them here while we're here now.
Your Honor, he was asking how the state jail is calculating time.
Mhm.
And I told him before that that's really up to the state jail.
That's exactly right, Mr. Minjares. As I mentioned, if you have questions for Ms. Martin, we have some other defendants that we have to take care of. If you're okay standing by or someone from your office, Ms. Martin, I can put you in a breakout room.
Yes, Your Honor. Thank you.
I just got one more question. Can I get my 80-20, please?
Again, I'm not sure what he's referring to, Ms. Martin. So Mr. Minjares, if you have questions for your attorney, I just need to take care of a few other folks and then we can bring you back, okay?
Judge Perez, real quick,
It's
Uh-huh.
fine.
if I may, ma'am, the 80-20, I know what he's referring to. It's basically a credit that the state jail calculates. And so however they calculate it, they're the ones that send notification to the court and then you approve or deny at that point. But they have to go ahead and generate that request.
So that's undetermined at this time, Mr. Minjares. Again, if it's something you want to speak with your attorney about, happy to put you in a breakout room, but it's not going to be right now.
Oh, ma'am, I'm fine. I'm fine with everything the way it is now.
Okay, well,
much.
if you're still around, just let the guards know if we're still here, okay?
Okay,
Thank you.
thank you all very much.
Who's next, Chuy?
Okay, Judge, if I may, Ms. Nava, does your client need an interpreter?
No, he does not.
Okay. Annex, if we could get Siqueiros next, please.
Yes, sir.
Mr. Siqueiros, this is Judge Bettis. Can you hear me okay?
I can, Your Honor.
Okay, perfect. I can hear you just fine too. Let's go ahead and get started, Chuy.
Yes, Judge. Cause number 2020-020-1322, State of Texas versus Rosendo Siqueiros. Announcement of council, please.
Brian Herrera for the state of Texas, ready, Your Honor.
Alyssa Nava, on behalf of Mr. Siqueiros, and we're ready to proceed, Your Honor.
We are scheduled for a plea today. In this case, Ms. Nava, do you see your client appearing from the jail annex?
Yes, Your Honor.
Okay, so I'm going to be asking you questions, so I need to swear you in. If you would please raise your right hand. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Do
Was that a yes?
Yes, ma'am.
Okay, thank you so much. You can put your hand down, sir. Sir, would you state your name for the record?
My name is Rosendo Siqueiros III.
Mr. Siqueiros, I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Siqueiros, do you recall reviewing that document with your attorney and signing that document?
Yes, I did.
Did you understand everything contained within that document?
Yes, I did.
Ms. Nava, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
Yes, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes, Your Honor.
Okay. Mr. Siqueiros, are you satisfied with your attorney's representation of you?
Yes, I am, Your Honor.
Ms. Nava, do you have any reason to believe your client is not presently competent to enter a plea?
No, Your Honor.
Mr. Siqueiros, have you ever been found incompetent by any court?
No, I have not, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, I have not, Your Honor.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
I am, Your Honor, yes.
Where were you born?
I was born here in El Paso, Texas.
Okay. So the charge against you in this case is driving while intoxicated, third or more offense. To that charge, what is your plea, guilty or not guilty?
Guilty, Your Honor.
Are you making your plea freely and voluntarily?
Yes, I am, Your Honor.
I will find you are making your plea freely and voluntarily. Mr. Herrera, would you summarize the evidence, please?
Yes, Your Honor. Had the state gone to trial in cause number 2020-0D01322, the state would have proven beyond a reasonable doubt that the defendant, Rosendo Siqueiros, on or about the 7th day of November 2019 in the county of El Paso and state of Texas, did then and there operate a motor vehicle in a public place while the said defendant was intoxicated, and it is further presented that at the time of performing an analysis of a specimen of the defendant's blood or breath or urine, the analysis showed an alcohol concentration level of 0.15 or more. It is further presented in and to said court that prior to the commission of the aforesaid offense, hereinafter styled the primary offense on the first day of September 1998 and cause number 970C10174 in the County Court at Law Number 2 of El Paso County, Texas. The defendant was convicted of an offense relating to the operating of a motor vehicle while intoxicated, and on the 18th day of December 2002 and cause number 2020C15314 in the County Criminal Court at Law Number 2 of El Paso County, Texas. The defendant was convicted of an offense relating to the operating of a motor vehicle while intoxicated. It's further presented in a two-set court that prior to the commission of the primary offense by the said defendant on the 23rd day of March 2017 in the 384th District Court of El Paso County, Texas, in cause number 2016 0D05883, the said defendant was convicted of a felony, to wit, driving while intoxicated, third or more, and said conviction became final prior to the commission of the primary offense. It is further presented in a two-set court that prior to the commission of the primary offense by said defendant on the 23rd day of March 2017 in the 384th District Court of El Paso, Texas, in cause number 2015 0D04544, the said defendant was convicted of a felony, to wit, while driving while intoxicated, third or more, and said conviction became final prior to the commission of the primary offense. And finally, Your Honor, is further presented into said court that prior to the commission of the primary offense by the said defendant on the 23rd day of March 2017 in the 384th District Court of El Paso County, Texas, and cause number 2015 0D03970.
Mr. Herrera, okay, first, please slow down. Are you saying 383rd?
384th.
Okay, I've heard 383rd a couple of times. Can you start at the 23rd day of March 2017? The last time you said that.
Yeah, the primary offense by the said defendant on the 23rd day of March 2017 in the 384th District Court of El Paso, Texas, in cause number 2015 0D03970. The said defendant was convicted of a felony, to wit, driving while intoxicated, third or more, and said conviction became final prior to the commission of the primary offense as stated in the indictment. At this time, Your Honor, the state will enter States Exhibits 1, 2, and 3. States Exhibit 1 being the plea papers, States Exhibit 2 being the Article 39-14 disclosure form, and States Exhibit 3 being the indictment and case summary.
Any objection?
No, Your Honor, no objection.
Without objection, States Exhibits 1, 2, and 3 are admitted. What is the plea agreement?
Your Honor, for TDC.
Ms. Nava, is that your understanding of the plea agreement?
Yes, Your Honor.
And Mr. Siqueiros, is that your understanding as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page trial court certification of your right to appeal. It is a document that explains your appeal rights. Because this is a plea bargain or negotiated case, you do not have an automatic right of appeal. Mr. Siqueiros, do you recall reviewing that document with your attorney and signing that document?
Yes, I do.
It's signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of driving while intoxicated, third or more offense, and I will assess your punishment pursuant to the plea agreement at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. You will receive credit for any and all time that you have served. Is there anything further, Ms. Navarro or Mr. Herrera?
Nothing further for the state, Your Honor.
No, Your Honor, but I just wanted to make clear, my client was concerned about the credit for time served issue, but I want him to be sure that you did order it on the record.
I did.
Yes.
Anything else?
No, Your Honor.
All righty. Good luck to you, Mr. Siqueiros. Thank you both.
May I be excused, Your Honor?
Yes, ma'am.
Thank you.
Who's next?
Annex, if we can get Luis Munoz, please. Luis Munoz, page 12, Judge.
Mr. Munoz, this is Judge Perez. Can you hear me okay?
Yes.
Great, I can hear you just fine. Let's get started, Chu.
Yes, Judge. It's cause number 2021-020-1622, State of Texas versus Luis Santiago Munoz. Announcement of council, please.
Brian Herrera for the state of Texas. Ready, Your Honor.
Julia Martin on behalf of Mr. Munoz, ready to proceed, Your Honor.
Ms. Martin, do you see your client appearing from the jail annex?
Yes, Your Honor, I do.
Sir, this is Judge Perez. I'm going to be asking you some questions, so I need to swear you in. Could you raise your right hand, please, to be sworn? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, sir.
Okay, you can put your hand down if it's still up. Sir, would you state your name for the record?
Luis Santiago Munoz.
Mr. Munoz, if you would stay looking at the camera, the only reason I tell you that is because when we move around, sometimes the machine does not pick up the audio, okay? Would you state your name again, please? Sir, would you state your name again, please?
Luis Santiago Munoz.
Thank you, Mr. Munoz. As we're here set for a plea today, I'm going to be asking you about documents that you may have reviewed with your attorney, the first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Munoz, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
I did sign that paper though.
Did you understand that paper, that plea paper?
Yes.
You reviewed it with your attorney?
Yeah.
Ms. Martin, do you have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor, I have.
And did you explain the plea papers to your client?
Yes, Your Honor, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes, Your Honor, I believe he did.
Mr. Munoz, are you satisfied with your attorney's representation of you?
Yes.
Yes?
Yes, ma'am.
Okay. Ms. Martin, do you have any reason to believe your client is not presently competent to enter a plea?
No, Your Honor, I do not.
Mr. Munoz, have you ever been found incompetent by any court?
No.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Yes, well, one time, I think, yes, one doctor said I was incompetent.
Ms. Martin, has he, do you know of any prior competency proceedings involving your client?
Let me check with that. I did not know any, Your Honor.
Yeah, I told her no the other day, so it's my fault.
Ms. Martin, in terms of your dealings with Mr. Munoz on this case, any issues that you've noted communicating with him regarding either the plea or the case, any possible offenses, anything like that?
No, Your Honor, none.
Okay, Mr. Munoz, I'm sorry, go ahead.
No, Your Honor, every time I have visited with Mr. Munoz, he has understood me. He knows what's going on. This is the first time that he's been represented by our office. So I don't see, anything that he was examined or found incompetent prior to this.
Okay, Mr. Munoz, you mentioned you may have, a judge may have found that you were not competent in a previous proceeding. Do you know when that was?
It was a doctor. It was the last time that I was here in jail, here in the annex.
Do you know how long ago that was?
I don't remember. It's been, I think, like what, 7, 8, 9, 10, like almost a year since, or more than 2 years ago. More than a year and a half.
Are you, do you have any mental health diagnoses that you're aware of, Mr. Munoz?
No. Well, I do. I have anxiety and I have, I'm schizophrenic.
Okay. Are any of those conditions preventing you from understanding what we're doing today?
No.
You understand that we are here for a plea in a felony case? Do you understand that?
What is that? Are you guys giving me aren't you guys getting me time served?
So what we're on a particular case that is a drug case. It is a state jail felony, possession of a controlled substance in penalty group 1 in an amount less than 1 gram. You have been charged by indictment with that crime. And today we are scheduled for you to either enter a plea of guilt or not guilt, meaning you're saying you did it or you are saying you didn't do it. Do you understand that that's what we're doing today?
Yes.
Have you been able to communicate with your attorney, Ms. Martin, at every point of this case?
Yes.
And she's been able to provide you with advice and you've been able to ask her all the questions you needed to ask?
Yes.
Okay. So if there is no other condition, anything impeding your client's ability to understand, it seems to me he does understand, Ms. Martin. And so, Mr. Munoz, I'm going to find that you are competent based on my observations and questioning of you and also the representation by your attorney. So I'm going to find that you are competent to continue today with your plea.
Okay.
All right. Mr. Munoz, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Phoenix, Arizona.
Okay. So as I mentioned, the charge against you in this case is possession of a controlled substance in penalty group 1 in an amount less than 1 gram. To that charge, what is your plea, guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Voluntary.
Okay, I will find you are making your plea voluntarily. Mr. Herrera, would you summarize the evidence, please?
Yes, thank you, Your Honor. Had the state gone to trial in cause number 2021 0D01622, the state would have proven beyond a reasonable doubt that the defendant, Luis Santiago Munoz, on or about the 6th day of March 2021 in the county of El Paso and state of Texas, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in an amount of less than 1 gram. At this time, Your Honor, the state enters States Exhibits 1, 2, and 3, States Exhibit 1 being the plea papers, States Exhibit 2 being the Article 3914 disclosure form, and States Exhibit 3 being the indictment and case summary.
Any objection?
No, Your Honor, no objection.
Without objection, States Exhibits 1, 2, and 3 are admitted. What is the plea agreement?
150 days confinement in the El Paso County Detention Facility, Your Honor, via 1244A.
Ms. Martin, is that your understanding of the plea agreement?
Yes, Your Honor, it is.
And Mr. Munoz, is that your understanding as well?
What is it?
That the plea agreement is 150 days confinement in the El Paso County Detention Facility, credit for time served. Is that your understanding of the plea agreement?
Yes.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. Next document I'm going to ask you about, Mr. Munoz, is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Munoz, do you recall reviewing that one-page document with your attorney and signing that document?
Yes.
Was signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram, and I will sentence you according to the plea agreement and in accordance with 1244A of the Texas Penal Code to 150 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Is there anything further, Ms. Martin or Mr. Herrera?
Nothing further for the state, Your Honor.
Your Honor, my client has exactly 150 days in the El Paso County Jail facility. We would request that a release order also be prepared and signed by Your Honor.
As soon as I receive it, I kind of get these right after we finish with them. So I don't have it yet, Ms. Martin, but I should be getting it. There's nothing else holding him, brother.
No, Your Honor.
Oh,
Not
okay,
that I'm aware of. Your Honor, this is my last hearing, so if I may be excused.
oh, okay, yes, yes, you may. For some reason, I thought you were gonna tell me like this was your last day in this court. I was
Me
about to have,
too.
I was about to have a heart attack.
Like what?
Well, it's nice to be wanted. Thank you.
All right.
No, we're here for the long run.
You may be excused for today, Ms. McKee.
Thank you. We'll see you Thursday then. Goodbye,
you.
everybody.
Bye, Julio.
Okay, it's time to- Yes.
Thank you, Mr. Munoz.
You know what time I'm gonna be getting up?
Álgame Dios. Who's next, Chuy?
Judge Teresa Garay, Annex, if we can get Teresa Garay, please.
Is she there or is she at downtown?
I'm sorry, Judge, it should be the downtown facility.
I
Annex,
think
we're done.
Yeah.
Well, we
the
have
last
one
two-
left, Judge, at the annex,
Who is that?
and that's Salvador Manuel Anchondo.
Let's do
But,
that one first.
Mr. Parra hasn't showed up. I tried calling him, but there's no answer. It goes to his voicemail and it hasn't been set up, so unable to communicate with him.
Okay, so let's take care of Annex. Let's get Mr. Anchondo. I thought both were at downtown. I must have been confused. We'll be right with you, Ms. Garay. Give us a second. We're gonna finish with the other jail first, okay?
Yes, ma'am. Thank you.
Salvador Anchondo, please. Annex, if we could get him.
Yes, he's coming.
Your Honor, was this the one that you guys said it was on Parra with Mr. Israel Parra?
Mm-hmm.
I didn't get a chance to forward you the pro se motion to withdraw, ma'am, but it is in Odyssey. I apologize for that.
Okay. Mr. Anchondo, is that you?
Yes, ma'am.
Okay, let's go ahead and get started, Chuy.
Yes, Judge. Cause number 2021-0D0200001, I'm sorry. State of Texas versus Salvador Manuel Anchondo. Announcement of council, please.
Brian Herrera for the state of Texas. Ready, Your Honor.
And I believe we were set for a motion to withdraw. I don't know if there was an addition. Let me just double check real quick. Bear with me, Mr. Anchondo. Motion to withdraw. Did Mr. Parra file a separate motion or was it just the letter filed by the defendant? Can somebody tell me?
Let me try.
It's
and-
just the letter, Your Honor.
Okay, I don't know who that was, but thank you. That's what I thought. I didn't see a separate motion. Okay, Mr. Anchondo, you have provided notice to the court. Hold on one second. Mr. Pantoja, did Mr. Parra receive, well, first of all, is he a court appointed? Can someone tell me if Mr. Parra was?
Judge, he is, ma'am.
He is, okay.
Yes, ma'am.
And have we had, I'm not seeing on Odyssey anything other than an arraignment back in September. Do we have any indication, Mr. Pantoja, whether Mr. Parra appeared for that arraignment?
I have to go back and check the dockets, Judge, if you
Okay,
like.
if you'll go ahead and do that. And he did receive notice of today's hearing, correct?
Yes, Judge, I did forward the Zoom invite to him, but he did not provide a read receipt. Yes, sir.
Okay, and I don't know, Ms. Aguirre, if you have access, he did receive notice, or maybe the clerk can tell me, can we tell when Mr. Parra received notice of today's hearing?
Judge, I did send it and I'm trying to confirm with Ms. Stewart now to see when or if he opened it, ma'am.
Okay. While we're waiting on that information, Mr. Anchondo, I did review the communication regarding the lack of contact. Have you had any contact with Mr. Parra?
As of today, no, I have no, Your Honor.
Okay.
No letters, no visits, no calls, nothing.
And let me check, let me look at the order of appointing. I don't know if we did or not. In any event, I am going to remove Mr. Parra as your attorney and going to appoint Joseph Vasquez. We're gonna come back in 1 week.
Okay.
For a status, let me see. Yes, because we don't have another setting until November. We will get the appointment order over to Mr. Vasquez. So he can get in touch with you, but in any event, we're gonna come back next week at 3 o'clock, the same time. So if in the interim, Mr. Vasquez reviews your case, needs to file something and we need to have a hearing, great, we'll have that time reserved. If not, at the very least, it'll be a time when we can just get on the same page, okay? So we will be scheduled in 1 week, but the order will go out probably first thing in tomorrow on the order appointing for Mr. Vasquez, and he will get in touch with you. But the yes, sir.
Sorry, is there any way that I could get his information?
I don't know that I have his information. I can tell you his name is Joseph Vasquez. As I mentioned, the order will go out to him immediately and he will get in contact with you. I don't know if you have any means to
No,
get it.
that's fine, Your Honor. Thank you. I could call, I could request to the law library and they can give me his information.
Okay.
Joseph Vasquez, correct?
Joseph Vasquez. We will be
Thank you, Your
back
Honor.
in 1 week at the same time on the Zoom at 3 p.m. so we can make sure you're present, okay?
Yes, ma'am. Thank you, Your Honor.
You're welcome. Let me see.
That should be the last defendant, Judge, for the annex.
Well, hold on a
Yes.
second. I want to, so Mr. Barra attended the arraignment on September 2nd. Did we get arraignment paperwork, Mr. Pantoja, do you know?
He didn't submit the arraignment paperwork, Judge. It was missing.
Okay, all righty. Okay, Sandy, when we get back tomorrow, we'll do the order removing, okay?
Yes, ma'am,
Wait
absolutely.
for the court appointed. All righty, thank you, Mr. Anchondo.
Thank you, Your Honor.
Take care. And now we can go to downtown, correct? Yes, downtown, sir. All righty. Okay, go ahead, Chuy.
Yes, Judge. It's cause number 2020-0D00269. Cause number 2018-0D04641. State of Texas versus Teresa de Jesus Garay. Announcement to council, please.
Brian Herrera for the state of Texas, ready, Your Honor.
Good afternoon, Judge. Brent Stevens for Ms. Garay, and we're ready also.
Mr. Stevens, you see your client appearing from the downtown jail?
I believe so. Judge, I spoke to Ms. Garay by telephone, so I've never met with her in person, so I believe that's her.
Ma'am, could you state your name and date of birth, please?
Teresa de Jesus Garay, March 26, 1974.
Okay, we're scheduled for a bond hearing. Mr. Stevens, you may proceed.
Thank you, Your Honor. Your Honor, my client is being held with no bond on her probation case from 2018. There's a new 2020 case, which is from November of 2019, which is $100,000 cash bond for that one. So currently, my client's 47. She's a naturalized U.S. citizen. She has children in El Paso. She has 3 sons living in El Paso specifically, and she can live with any of her sons here if released. She also indicates she has employment waiting for her if released. So she's been in El Paso a very long time, will be here if released. She does have a GED, previously worked for the state for, she says 18 years. This is a case, Judge, where my client was referred to BHRTC by the court, successfully completed it, reported for a very short time after that, and then absconded. And she does have mental health issues, bipolar and PTSD. Part of the problem stemmed from a divorce that happened right at that time. So I guess, she basically fell off the wagon, and once she had a warrant, just never turned herself in. So I've spoken to Ms. Garay about several options. The one that she would like to pursue is requesting the court to give her an opportunity to prove that she will report And she is insistent, Judge, despite the period that she's been absent, that she will report to the court and she will stay clean. My recommendation to her was for rehab, and I told her I'd have to talk the court into that option. But this is the pursuit she would prefer, which is to prove to the court that she will be able to do it on her own.
Okay, well, she's already proven to the court that she doesn't want to do it on her own. So let's just hold up. Mr. Herrera, you have any input on this?
No, Your Honor, obviously, Mr. Stevens addressed the state's concerns that the defendant previously, did abscond, and is why we filed the motion to adjudicate guilt on the present case. Now, I mean, there's just one other DWI, misdemeanor DWI conviction that was lowered from 2005, and then obviously the deferred and then the most recent 2019 possession.
Is there any non-Texas criminal history?
Not that I'm aware of, Judge. Just the local ones.
So, Ms. Garay, why am I supposed to believe you're going to complete the treatment that you already showed me that you cannot complete?
I'm really looking forward to being with my family. I was right after my release from BHRTC, I was left with no home, no husband, and I fell off the wagon, like he said. And I've met people throughout this through my journey that are willing to help me, that are willing to be there for me. It's not a drug problem that I have. It's how can I say it? All the years that I've worked, all went down.
So let me stop you right there. I mean,
Yes.
if it's not a drug problem, why are we looking at, I'm not looking at BHRTC. I mean, my first thought was Mr. Stevens, well, we have a new drug case, but if we don't have a drug problem, this is a compliance problem, and circumstances can be hard, but I don't know how throwing more resources at Ms. Garay, helps her to make better decisions. I just don't.
Well, Judge, at this point, we're simply requesting that she be given a PR bond until we can come back before the court for the revocation.
So a straight PR bond is going to be denied. She has no bond on 4641. She's on deferred there.
Yes, Judge.
Yes, okay, so she's entitled to a bond there. She will have a $50,000 bond on the 2018 case. What did you tell me the bond was on 0269?
It's $100,000.
And is that some kind of PR revo? So because I'm showing a $3,000 cash surety, or who's here from the clerk's office? Can somebody? I'm sorry. Can you tell me what was there a bond prior to the 100,000 on the 2020 case?
I'm checking, just one moment. It was a bond surrender from the bonding company.
Ms. Stewart, do you see an amount prior to the surrender though?
Prior to that, the bond was 3,000 cash surety.
Yeah. Does she have what kind of resources does she have, Mr. Stevens?
Very little, Judge. I don't think she would be able to come up with too much. How much do you have, Teresa?
I have my land, it's
How much money do you have?
how much money do you have? But I really don't have much money. But the land is still under my name.
Okay, so you have a property in El Paso?
Yeah, my house burned down 3 years ago. And
Okay.
so the land is still under, well, it's actually under my son's name.
All right. Thank you, Teresa.
Okay, so this was a transfer from the 346. Okay, we're gonna do on 0269. We're gonna go down to a $10,000 cash split bond, $10,000 cash, $5,000 cash surety, $5,000 PR to report weekly. Does she have a place to live, Mr. Stevens?
Yes, Judge, she can live with one of her sons to start with.
Okay, report weekly, use no illegal drug, no alcohol, curfew 9 to 6 unless she's working or going to school. Subject to testing, commit no new offenses, can't change place of residence, maintain current contact, and may not leave El Paso County without court permission. And then we'll see where we are after this.
Okay.
Alrighty.
Thank you, Judge.
I don't know if there's a mental health angle on this, Mr. Stevens, but if we're to explore anything else, please be prepared to have some more information for the court and any potential resources that you feel might address any issues she has, okay?
I think if you want to go ahead and make it part of the Takumi order, I would recommend that, the PR order, I'd recommend that she be referred to Takumi, and our office will refer her to Takumi upon release.
Okay, that'll be part of the PR bond order as well. When's our next setting? Let's see, we have a final hearing plea deadline on 10/26 on the new case. I gotta think the other case may be running the same. So we'll see where we are.
Okay, thank you, Judge.
Alrighty, thank you very much. Good luck to you, Ms. Garay. Who is next? Chewy, is that everybody?
Judge, we have one more defendant, George Lopez. Annex, if we can get George Lopez.
Are you? Stop, Mr.
Your
Herrera.
Honor, Your Honor, he's downtown. I need to switch floors real fast. But
Sure, go
George-
ahead. Let's
George
take
Lopez
a
is
quick,
downtown.
take a quick break from YouTube.
Okay, Judge. Sandra, can you take us off YouTube? I'm not the host.